working on the Bihar matter, apna SIR wala. So please explain to everyone why this has actually reached the Supreme Court. What exactly the matter is all about.
What is concerning about the whole exercise, about this revision of voter list in Bihar, is, in my opinion, actually threefold. One is the timeline or the timing. You can call it timeline/timing. Second is the accuracy of the exercise. And third is the right to appeal to an individual voter in Bihar. In fact, it has never happened in independent India where on mere non-submission of a form, an existing elector has been chucked out from the voter list.
Do you think somewhere or the other it should have been the state's accountability as well to actually keep the voter list? They also knew the elections are coming. So वो accountability कौन लेगा इस समय?
I think politics should be done on the streets and legal battles should be fought in court of law. Simarjit, lawyers advise what suits their pocket the best. So lawyers do not always give the best legal opinion. Lawyers give the best opinion which will probably keep the business going.
So guys, आज वकील वानी में today we are having Harshit Anand, advocate. So he works very closely in the Supreme Court and he has been briefing a lot of senior advocates in the constitutional matters. Article 370, Waqf Board, Minority, AMU. Then the recent one which we are going to discuss at length is the Bihar SIR matter. And today in this episode, you'll be learning that what exactly the whole matter is about, what the legal issues which he is dealing with. Along with that, we will be also understanding that this constitutional law practice is not just limited to the Supreme Court, but to High Court and trial courts as well. And I am sure you will be learning a lot of things from this episode. Please don't miss this one. Thank you. Hello everyone and welcome to another episode of Vakil Vaani. Harshit Anand, welcome to our podcast. Constitutional lawyer.
Hello, Simarjit.
क्या होता क्या है कॉन्स्टिट्यूशनल लॉयर जब अपनी प्रोफाइल के साथ लिखते हैं?
कॉन्स्टिट्यूशनल लॉयर इंडिया में, सिमरजीत, इफ आई वर टू टेल यू, इंडिया में कॉन्स्टिट्यूशनल लॉ प्रैक्टिस रिमेन्स बिट ऑफ अ मिसनॉमर बिकॉज लोगों को लगता है कि कॉन्स्टिट्यूशनल लॉ प्रैक्टिस ओनली रिलेट्स टू प्रैक्टिसिंग इन द सुप्रीम कोर्ट और हाई कोर्ट, कुछ कॉन्स्टिट्यूशनल इम्पोर्टेंस वाले केसेस करना. फॉर एग्जाम्पल, आपने अगर किसी बड़े केस पे काम कर लिया, फॉर एग्जांपल आपने अगर आर्टिकल 370 की वैलिडिटी पे काम किया,
जिस पे आपने करा ही था,
या आपने इलेक्टोरल बॉन्ड्स पे काम किया, तो लोगों का एक जनरल परसेप्शन जो है, लॉयर्स का भी है, कि दिस इज कॉन्स्टिट्यूशनल प्रैक्टिस. एक्चुअली कॉन्स्टिट्यूशनल लॉ प्रैक्टिस वुड मीन एनीथिंग दैट रिलेट्स टू इन्फोर्समेंट, इम्प्लीमेंटेशन और प्रोटेक्शन ऑफ कॉन्स्टिट्यूशनल प्रोविजंस इन केस ऑफ वायलेशन. और इंडिया में चूंकि कॉन्स्टिट्यूशनल कोर्ट्स दो लेवल पे ऑपरेट करती हैं. एक हाई कोर्ट्स हैं हमारी, जो कॉन्स्टिट्यूशनल कोर्ट्स हैं, जहाँ पे आप रिट पिटिशंस फाइल करते हैं, जहाँ पे लेजिस्लेशंस की वैलिडिटी टेस्ट होती है. और जो आपका हाईएस्ट कॉन्स्टिट्यूशनल कोर्ट है वो तो सुप्रीम कोर्ट है ही. बट इन दोनों कोर्ट्स के अलावा भी कॉन्स्टिट्यूशनल लॉ प्रैक्टिस हमारे ट्रायल कोर्ट्स में भी होती है. इसका अगर मैं एक छोटे से एग्जाम्पल से आपको एक्सप्लेन करूँ कि क्यों मैं ऐसा कह रहा हूँ. अगर आप एक सिंपल अरेस्ट का केस देखें इंडिया में, तो हमारा कॉन्स्टिट्यूशन ये कहता है कि 24 घंटे के भीतर जो अरेस्टी है उसे आपको मैजिस्ट्रेट के सामने प्रोड्यूस करना है उसकी अरेस्ट की वैलिडिटी जस्टिफाई करने के लिए, जिसे हम रिमांड हियरिंग कहते हैं. नाउ इन माय ओपिनियन, अ रिमांड हियरिंग इन इंडिया, और अ लॉयर रादर हु इज अपीयरिंग एंड आर्ग्यूइंग अ केस इन अ रिमांड हियरिंग is doing as much a constitutional practice as any other advocate arguing a case of constitutional importance in the Supreme Court. Because आप रिमांड हियरिंग में क्या कर रहे हो, आप किसी की लाइफ एंड लिबर्टी प्रोटेक्ट कर रहे हो.
Correct.
आप उसकी आर्टिकल 21 की जो राइट है उसके लिए आप लड़ रहे हो. तो अगर किसी की अरेस्ट इलीगल है, इनवैलिड है, तो आप उसे रिमांड के स्टेज पे पहली बार फाइट करते हो. एंड दैट इज व्हाई इट इज वेरी वाइडली बिलीव्ड दैट आवर मैजिस्ट्रेट्स or these lawyers who are practicing before magistrates in these remand hearings, they are the foot soldiers of the constitution. They are in fact the first line of defense of the constitution, in other words. तो constitutional law practice काफ़ी चीज़ें हो सकती है हमारे देश में, because हमारा law भी ये कहता है कि no legislation, no regulation, no notification can be ultra vires the constitution.
Correct.
Everything has to be in sync with the constitution. So if there is a simple procedural lapse in, say, award of a public tender, पब्लिक टेंडर जो एक मान लीजिए एक सरकारी संस्था अगर किसी को दे रही है तो सरकारी संस्था का दायित्व है कि वो सबको इक्वल अपॉर्चुनिटी दे. वो फेवरेटिज्म नहीं कर सकती है. वो ऐसा नहीं कर सकती है कि वो मुझे आपसे ज्यादा अपॉर्चुनिटीज दे. तो हमारा कॉन्स्टिट्यूशन एक ऐसे मामले में भी पिक्चर में आता है जो कि एज सच कॉन्स्टिट्यूशनल नहीं है, एक कमर्शियल टेंडर है. बट वहां भी आपको कॉन्स्टिट्यूशन को दिमाग में रखना है. So constitution is everywhere. You have to argue it maybe before an arbitral tribunal. You have to argue it before a trial court. It can be before the Supreme Court if you are arguing something that is of constitutional importance and can only be decided by a bench of say 3 judges, 5 judges, whatever the law says. So in my view, that is the ambit of constitutional law practice. I have done, when I say I have done, I mean I have assisted as a junior counsel my senior, Mr. Shadan Farasat, other seniors in the course of arguments in the Supreme Court and in the High Court in different matters. So there are certain matters of constitutional importance that I have worked on. But yeah, to just cut the whole story short, constitutional practice can be anything. It's like, not a hard and fast.
We have just started and I have already learned what exactly the ambit of constitutional practice is, which is very good. But Harshit sir, aapne first you did started with Khaitan in Kolkata, and then you did some trilegal work with trilegal here in Delhi, and then the constitutional. You directly went into the chamber practice for before the Supreme Court most of the time.
Right.
What made you what had you in your mind कि यार मुझे यही practice में अंदर जाना है?
So to be honest with you, Simarjeet, I am not lying when I say that no strategy has gone into it. I was mostly a transactional lawyer with a very keen interest in constitutional law. I will not deny that because I used to do a lot of moot court competitions when I was in law school. And most of those moot court competitions revolved around questions of constitutional law. Correct. And from the very beginning of my legal career, I used to find issues of constitutional importance interesting. So जब मैं एक ट्रांजैक्शनल लॉयर भी था खैतान में ट्राइलीगल में, it was not as if I was not interested in what was happening in the constitutional sphere by virtue of not being a part of it. I was keeping abreast of it. I was reading up on it. I was trying to think of legal arguments even if I was not a part of the litigation, because that's what you're supposed to do as a lawyer interested in a discipline of law. My journey into constitutional law practice, assisting constitutional lawyers in courts, was a very lucky accident. I luckily found Mr. Farasat's chamber. He was kind enough to take me in, trust my abilities, even though I didn't have a lot to show for it in terms of work experience. But he reposed decent enough trust in me. And then whatever work opportunities I got off working on constitutional law matters. For example, when I worked on the Electoral Bonds case, we spent a lot of time, me, my colleagues, sir, we spent a lot of time discussing. What happens is you get to speak for, or your senior gets to speak for 30 minutes or an hour at max in courts. But the amount of work that goes behind it, the amount of preparation that goes behind it is for hours and hours. Because what you also have to keep in mind as a counsel in these matters is that there are a general bunch of arguments available to everyone.
Correct.
Because these are matters of national importance. These are matters which interest everyone. So there are certain arguments which are available to everyone. And those arguments will always go to court. You can rest assured that whoever gets to go first, whoever gets to speak first in court, will always make those arguments. So you always also have to think of something novel. What new can you offer to the matter? How exactly can it help achieve an objective which maybe others have not thought of, even on your side of the bench? So the work behind these matters is quite a lot. In fact, I would say that the work mostly is of thinking rather than doing something. Then in some matters, what also happens is, for example, I'll give you an example of one of the 7-judge bench matters that we did before a 7-judge bench led by Justice D.Y. Chandrachud. And it was one of those matters where we were the leading petitioners. So we were the lead counsels in the matters.
What was the matter?
The matter was about subclassification in reservations.
Right, right. AMU, Aligarh Muslim.
No, the AMU matter was a separate matter.
Acha.
The subclassification in reservation matter was actually a matter that emanated from a legislation in Punjab,
Okay.
and that was decided against the state because it was held that because there was a Supreme Court judgment at that point of time which held field and which said that there cannot be further subclassification in the percentage of reservation that has been allocated to a community. So if say X community has been allocated 5% reserved seats, so there cannot be a further subclassification in favor of further subgroups within that community or caste. So that law was changed by this 7-judge bench. We argued in favor of change of law.
Very nice.
But what I was trying to tell you is that in that matter, since we were the lead counsel, so a lot of responsibility lay on our shoulders because the matter would go in the direction that we would take the matter in. Because the bench entirely depends on you for assistance. Any bench, either in the Supreme Court or in the High Court, in a matter like this, will rely on the counsels. The counsels have to show the way to the bench. And then the bench will ask whatever questions occur to the bench, whatever they think is within the contours of constitution, whatever they think is extra constitutional. So in that matter, we had to basically argue for the whole first day. And a lot of work went into the matter. We had to prepare written submissions of over 100 pages. We had to brief our seniors. We had to think of all kinds of questions that could come from the bench. So coming back to my original point, in constitutional law practice, and especially these matters which anyway attract a lot of public eye, and most lawyers are aware of those easily available set of arguments A, B and C, you have to walk that extra mile to find a new elusive argument that maybe others have not thought of. And that is the hard yard.
Correct.
Yeah.
So right now you're working on the Bihar matter, apna SIR wala.
Right.
So please explain to everyone why this has actually reached the Supreme Court. What exactly the matter is all about.
So if I were to tell you the legal controversies involved in the matter, first of all, let me just give you a brief background as to what is happening. This process is called a special intensive revision of electoral rolls. And the Election Commission of India, which is the constitutional functionary entrusted with the power of creation of electoral rolls and also conduct of elections in India, they have the sole authority and the power to do it. What is concerning about the whole exercise, about this revision of voter list in Bihar, is, in my opinion, actually threefold. One is the timeline or the timing. You can call it timeline/timing. Second is the accuracy of the exercise. And third is the right to appeal to an individual voter in Bihar. Now, these are not very independent. These are not standalone points. These are all related points. But I'll try and explain to you why these are concerning even from a legal perspective. I'm not going into the political part of it. I'm not going into what are the political ramifications or the political problems with it. So see, solely in terms of timing. So Bihar Assembly gets dissolved sometimes in the 3rd or 4th week of November.
Okay.
So you need to have a freshly elected assembly before that time, which also means that sometime in October or early November, latest by early November, you need to have new elections, state elections in Bihar. Now, a state election mandates a final list of voters. Now, what the ECI has done is, without any consultation with political parties, without any heads up or information to the most important stakeholders, which is the voter, without giving them any fair warning, suddenly on one fine day in the last week of June, they came up with a press note and a detailed guideline to say that we are commencing this exercise of revision of rolls, an intensive revision of rolls. So we also have to keep in mind that ECI has 2-3 kinds of revisions available.
Okay, so what is this intensive?
So the usual revision of rolls is something which is called a summary revision.
Okay.
And this is an ongoing exercise because people keep getting added and deleted from voter lists. People die, people shift out of cities all the time. So this summary revision is something that Election Commission in all parts of India keeps doing on a regular basis. For example, let me give you an example from Bihar. So after the Lok Sabha elections of 2024, as recently as January 2025 and April 2025, ECI has done 2 rounds of summary revisions in the state of Bihar. So this so-called purification of roles is something that was already happening and something that had happened as recently as April. Now suddenly, without any fair warning, without any pre-consultation, you come up with a notification in the last week of June, I'm sorry, and then you say that we are going to do this beginning tomorrow, and you have to submit a form. If you don't submit a form, your name will not figure on the draft electoral roll.
Oh my God.
Now, the problem with this exercise is the timeline, like I told you, because we really don't have any time before the elections are happening. The second point, which I told you, is of accuracy. Now, look at the process. Let me just give you a brief gist of the process. In the first stage, which has already happened by end of July, they asked all voters, everybody. I am a voter in Bihar, so even I had to submit a form, an enumeration form, a so-called enumeration form. And if you fail to submit that enumeration form, your name in fact gets deleted from the draft electoral roll. Now, it may sound as something very innocuous or harmless. It's a draft roll. आपका नाम कट जाए तो क्या दिक्कत क्या है? आपका नाम final roll में आ जाएगा. But the problem is there is a legal issue attached with it. We have something called the Representation of People Act 1950 in this country. A very old law of 1950 when India became independent. And that law is still followed, under which your list of electors for every state is created and then revised from time to time, like I told you. There's a particular rule under that law. It's called the Registration of Electors Rules of 1960.
Okay.
And that rule has a very specific provision which requires an in-person hearing and a full-fledged notice to every individual whose name is proposed to be deleted from the elector list, who is already on the rolls. And if you are willing to, or if you are planning to remove their names, they have to be given an in-person hearing. It is a very detailed process, and rules of natural justice are inbuilt in that rule. In the 1990s, in a case where something like this happened, the Supreme Court had a 3-judge bench of the Supreme Court, in fact, had an opportunity to interpret those rules and also interpret what it means to continue on the electoral rolls as a voter.
Okay.
And the Supreme Court recognized an inherent right of an elector whose name is already there on the electoral roll. And this right was to continue as an elector unless the process envisaged under the Act and the rules were followed to remove you from that role. And this is not something that the Supreme Court devised out of nowhere. If you look at the relevant constitutional provisions, which form the bedrock of universal adult franchising in India, Articles 325, 326, you will see that a collective reading of all these articles ensures that every adult citizen in India who is otherwise qualified to be on the rolls has a right to exist and continue on the rolls. And this is the system that we have followed from independence. Here, it is not an individual's responsibility. It is not Simarjeet's responsibility to go to the election commission and say that, look, I am eligible. You put me on the rolls. These are my documents. It is the state's responsibility. It is in fact the ECI's responsibility to find you as an eligible adult citizen and ensure that your name is on the roll. This is in fact the architecture of how elections happen in India. Now, this is the first time that architecture is being turned on its head. And the voter is being told that we are chucking out everyone. This is a fresh preparation of rolls. You come with documents. And if you don't have documents in the next 30 days, which by the way is also the flooding season and the monsoon season in Bihar, which by the way is also a state with the highest number of migrant workers, the feasibility of the exercise is in question. And that is what has prompted political parties to question the intent or the motive of an independent constitutional functionary like the Election Commission. So while the threshold of imputing motive or malafide on a constitutional authority is very, very high. But if you take all of these things into account, the hurried manner in which it is happening, the chances of unforced error, the point of accuracy that I was trying to tell you, even if I were to believe that the ECI is doing it out of the goodwill or out of the intention of purifying the voter list, so to speak, this is to use their own language. They say that this is purification of rolls. The problem is, if there is an ERO sitting in Bihar or an assistant ERO sitting in Bihar processing 3,000 applications per day, what are the chances of accuracy there? What are the chances of human errors? Because at the end of the day, that ERO is a human being. That ERO has human limitations. So you are basically allowing for mistakes to happen. And in the first round of this SIR exercise, in the house-to-house enumeration exercise, 65 lakh people have already been chucked out. Now the Supreme Court has passed orders that everybody who has been wrongly chucked out of those 65 lakhs, there's a different breakup that the ECI has given of X number of people who have died, Y number of people who have permanently shifted. But the issue is there is no basis to these numbers, because all of this exercise, number one, has happened in a very hurried manner. Number two, this has all been done by booth level officers who have not collected any documents to justify these claims. They have simply collected forms from whoever has given those forms.
There's no verification.
So there is no verification. You don't know what is the basis of this claim that somebody has died. And that is why you saw a few days ago that there were people in the Supreme Court who were otherwise said to be dead by the Election Commission.
Correct.
But those people, an 85-year-old lady was there in the Supreme Court saying that, look, I have been marked dead, but I'm here. And you can imagine that out of 65 lakhs people, there can be so many people like that. And the last part, let me just wrap it up very quickly. The part of them not having a right to substantive appeal is again linked to my first point, the timeline. Because you know that the elections have to happen in the next 30 to 60 days. And even if a voter, what the Election Commission says that, look, even if you get chucked out, even after all precautions, if you get chucked out, you still have your remedies available under law, which is the remedy available under the 1950 Act and the rules framed thereunder. The problem is, if I were to avail those remedies, if I have been chucked out, I would still cross the timeline of the elections.
Those remedies are too much time taking.
See, I wouldn't say that those remedies are too much time taking, but it won't be humanely. See, the remedies allocated have a time period of 15 to 30 days.
Okay.
But if those remedy were to begin at the end of September, because the final list is to be published at the end of September, and the elections have to happen in October.
There's
and
no time.
There are levels of appeal. There is no real time.
Correct.
So at best, what can happen is they'll say that, yes, we'll look into your appeal, but for this election, you're gone. So the level of, I would say, illegalities are manifold. And that is why there is so much clamor, there is so much halla gulla about this issue, as you can see in the news.
Yadavendra Yadav ji was also there in the Supreme Court, and he had a very good flow of arguments. Much
Absolutely.
better than
See, so Yadav is somebody who has more than 2 decades of experience doing this. Honestly, the kind of insight that he brings into this is, it's very difficult for a lawyer to bring something like that, because lawyers, rely on briefings.
Correct.
And Mr. Yadav is somebody who does this day in and day out. So I am honestly of the opinion that his submissions that day on the 12th of August were very, very crucial in making the court understand as to what is at stake and how this process is different from the so-called special intensive revision that took place in 2003, which ECI goes back to every time they argue, saying that this is not something unprecedented. This has already happened in 2003. And if I'm not wrong, in his arguments, Mr. Yadav pointed out very clearly that what happened in 2003 was not this. In fact, it has never happened in independent India, where on mere non-submission of a form, an existing elector has been chucked out from the voter list.
Okay.
And he made those points very succinctly, very clearly before court, and I think all those points went home.
So, just to cut you in between, what used to happen earlier, say if I am not able to submit that form, I was still there, or I was just removed from the voter list?
No, so see, this enumeration form is not something that was a part of the law earlier.
Okay,
It was
so this is the first time they actually
So this
introduced it.
enumeration form, if I were to call it that, if I can call it that, is an invention of the ECI. This enumeration form with those list of 11 documents that you hear about in the news is a new invention by the ECI. Because if you look at the statutory scheme, if you look at the act and the rules, for any new elector to come on the rolls, there is something called a Form 6. And in Form 6, there's a list of documents. It includes an Aadhaar, a driving license, a PAN card, or even a self-certification that I am a citizen of India and I'm otherwise ordinarily resident in this constituency. So those documents have been chucked out, and a fresh list of 11 documents, the availability of which also is of concern in a state like Bihar, where documentation is otherwise very poor. So, like I was telling you, Simarjeet, the problems lie at every level. The problem is of timing, the problem is of workload, the problem is of right of appeal, the problem is of availability of documents. And lastly, you have to look at the state that you're talking about.
Correct. I was coming to that. So what about like in other states? How have they managed to update their electoral lists every time?
So going back to what I was telling you earlier,
Maybe taking an example of one of that state which has not that much of migrant people leaving that state.
so if I were to, let's take an example of a city like Delhi. Delhi also had its elections recently. See, like I told you, going back to my previous answer as to what are the different kinds of revisions, there's something called a summary revision, something called an intensive revision. The usual practice is that in a year where elections have to take place, you do not do intensive revision.
Okay.
Because intensive revision, like the name itself says, is intensive. It's a deeper checking. It's a checking at different levels. Your citizenship may be checked. Your status as a resident of an area may be checked. Your other documents may be checked. A summary revision is simply checking whether a person who was on the roll continues to be on the roll or has ceased to be on the roll, either on account of death or on account of migration, or if there are duplicate entries, one entry has to be removed from the roll on which that person does not reside anymore. So this is a process that goes on in all states, and as we speak, this is a process that is going on in multiple states in India. But again, coming back to the central point, that in a state which is to go for elections in the next 3 months, you do not undertake an exercise like an intensive revision, especially in a state which has, number one, monsoon and flooding problems, because you see that parts of Bihar right now are flooded as we speak. Those people are looking for shelter while you're asking them for documents. Number two, this is a state with highest number of migrant workers. You know, Biharis work in all states of India. And thirdly, the documentation penetration is very, very poor. You have not, as of now, there's still no clarity on whether those 7.24 crore people on the draft roll right now, whether their Aadhaar will be accepted or not. Be that as it may, on the ground, the ERO, the officer is not accepting Aadhaar because their instruction from the ECI is that Aadhaar is not a valid document of citizenship.
I'll come to the next question.
Yeah.
So हर्षित सर, जैसे आपने ये पूरा समझाया कि ECI ने एकदम नए रूल्स लेकर आया उसके वजह से, do you think somewhere or the other it should have been the state's accountability as well to actually keep the voter list? They also knew कि elections are coming.
Correct.
So वो accountability कौन लेगा इस समय?
So see, Simarjeet, I'll go back to my original argument which I was giving you. देखो, दुनिया में 2 तरीके के सिस्टम्स हैं इलेक्शंस के. इलेक्शन के नहीं बोलूंगा मैं, इलेक्टोरल रजिस्ट्रेशन के. एक सिस्टम है जो हम लोग फॉलो करते हैं, एक सिस्टम है जो कुछ और देश फॉलो करते हैं, जहां पे रिस्पॉन्सिबिलिटी वोटर की होती है कि वो जाके अपने आप को रजिस्टर कराए ताकि वो वोट दे पाए.
ठीक है.
जो सिस्टम हम फॉलो करते हैं, जो सिस्टम हमारा संविधान फॉलो करता है, जो हमारे कॉन्स्टिट्यूशनल फ्रेमर्स ने एनविसाज किया था व्हाइल दे वर हैविंग दोस डिबेट्स इन द कॉन्स्टिट्यूएंट असेंबली, वहां पे हम चाहते थे, पहली बात तो हमने वोट करने का अधिकार सभी को दिया, एक साथ दिया. हमने ये अधिकार बिना जाति देखे, बिना धर्म देखे, बिना लिंग देखे हर इंसान को दिया, हर अडल्ट इंडियन को दिया।
आप 18 के हुए आप वोट
आप 18 के हो, आप
हाँ।
भारतीय हो
हाँ।
और आप एक जगह के स्थायी निवासी हो, आप वहां वोट करोगे। और इसीलिए हमने अपने इलेक्शन कमीशन को ये जिम्मेदारी भी दी कि आप सारे अडल्ट इलेक्टर्स को आप चेक करो व्हाट इज द इलेक्टर टू अडल्ट पॉपुलेशन रेशियो। अगर किसी जगह 100 अडल्ट हैं, 100 अडल्ट रह रहे हैं, तो इलेक्शन कमीशन का दायित्व ये है, उसकी रिस्पॉन्सिबिलिटी ये है कि वो बेस्ट के सिनेरियो उनका एफर्ट होना चाहिए कि वो सारे के सारे 100 लोग इलेक्टर्स जो हमारा लिस्ट है, इलेक्टोरल रोल है, उस पर फिगर करें ताकि वो जाके वोट दे पाए, अपना जो वोट करने का उनका कॉन्स्टिट्यूशनल लीगल राइट है उसको एक्सरसाइज कर पाए। बिहार जैसे स्टेट में ये वोटर टू अडल्ट पॉपुलेशन रेशियो ऑलरेडी परफेक्ट नहीं था। किसी किसी स्टेट्स में रेशियो बहुत अच्छा है। जैसे मैंने आपको बोला कि हम दूसरा सिस्टम फॉलो करते हैं। फ्रॉम इंडिपेंडेंस इट हैज बीन द इलेक्शन कमीशंस रिस्पॉन्सिबिलिटी टू इंश्योर दैट इफ देयर इज समबडी, an adult person who is not on the roll, they should bring that person on roll. So it is actually the constitutional functionary's responsibility.
Correct.
बिहार में जो रेशियो था, जैसे मैं आपको बता रहा था, ये ऑलरेडी कम था। इस एक्सरसाइज के बाद ये रेशियो और भी कम होगा। इनफैक्ट आप देखिए फर्स्ट लेवल के बाद 65 लाख लोग इस लिस्ट से निकल चुके हैं। एंड अनलेस इन दिस वेरी लिमिटेड टाइम they're able to submit their documents, they will be out. They will not figure back unless we have subject to whatever proceedings are going on. तो आपने एक्चुअली क्या किया है कि आपने आपका जो अकाउंटेबिलिटी का क्वेश्चन था, आपने अकाउंटेबिलिटी रिवर्स कर दी है।
You have put it back on the voter.
The onus has been put on the voter when the constitutional scheme, the constitutional architecture of universal adult franchising puts the onus on the functionary, on the election commission.
Okay.
It is not the individual's responsibility. This is not the United States of America where I have to go and register myself.
It is not even the responsibility of the state.
It is the responsibility of an autonomous, independent body.
Understood.
Created under the constitution and is actually has only one function. That body only has one function, to bring as many people as possible on the electoral rolls and then conduct elections.
Conduct it properly.
That's it.
We won't go into that side of the debate जो आजकल चल रही है थोड़ी ज़्यादा, वोट चोरी and all, क्योंकि वो थोड़ा सा political.
That's a political debate. See, the politics of it. See, every case of constitutional importance, of legal importance in India or anywhere will have a political side of it, right?
Correct.
But of course, that political side of things does not play out in a court of law. I mean, you cannot stand in a court of law and make political arguments saying that the ECI is... You can say that the ECI is not probably fulfilling its constitutional mandate because that is still a constitutional argument to make. But to directly impute motive without having credible evidence or on the basis of speculation or maybe some...
Your own research, you can't just...
I mean... Unless you have something very credible and you think that that is something that will hold good as evidence in a court of law, in my view, one should steer clear of mixing politics with law in a court of law because on most occasions it's counterproductive. I think politics should be done on the streets and legal battles should be fought in court of law.
I think I'll be using that same thing in my reel as well. Very good, like politics should be done on streets.
Exactly, because if you do the opposite, if you do your legal practice on the streets and if you do your politics in the court of law, I don't think you're going to get desired outcomes.
Correct.
So politics should be left to politicians. Lawyers should do law in courts of law.
Going deeper on the law side, recently there's one more thing which happened in the Allahabad High Court. Like we saw the united front of the lawyers and the judges there. So what are your views? What exactly happened and then what actually came through out of that?
So Simarjit, in that case, I think the unfortunate part was not what happened with the said Allahabad High Court judge, but the manner in which it happened. See, what happens sometimes is the Supreme Court also has to find a way to modulate its order so as to not affect
the trust which everyone has.
I wouldn't even call it trust. I would say, see, the Supreme Court enjoys its validity from the acceptance that people have about its order, from the finality that it enjoys.
Hmm.
And the Supreme Court enjoys finality because of a widespread belief that the court also knows the limits of its powers. Now, the Supreme Court was right in passing strictures against the judge, because if the court thought that the matter was of civil nature, it should not have been given a criminal color, and the judge clearly did that in the Supreme Court's opinion, then the Supreme Court was justified in passing strictures.
But did Supreme Court had that power?
But the power to
Huh.
take the criminal roster away from a sitting High Court judge, who, by the way, in the constitutional framework, is not below a Supreme Court judge. In our constitutional framework, the High Courts and the Supreme Court are in juxtaposition. The High Court, so to speak, are not below the Supreme Court.
Correct.
It's a judge of a constitutional court that you're talking about.
Hmm.
So the power to take away a roster or give a roster to a judge always and only rests with the Chief Justice of that particular High Court. Now, the Supreme Court, to override that power and give a blanket direction to the Chief Justice to take away the criminal roster, is, in my opinion, a kind of an overstepping that could have been avoided. Like I told you, the Supreme Court was well within its limits and very well advised to, or the judge in their good sense were right in passing strictures, because it is actually very wrong practice to give criminal color to matters of civil nature.
Correct.
And we see that happening day in and day out in our
the
courts.
magistrate court, the district
You see that
courts,
happening every
yeah.
day, and that is something that has to be curbed. As lawyers, we know that that tendency has to be
I
stopped.
have seen lawyers only, like, without naming anyone, without directing it, but lawyers also sometimes advise it. That
Simarjit,
I think it is more of the desperation of the clients.
Simarjit, lawyers advise what suits their pocket the best. So lawyers do not always give the best legal opinion. Lawyers give the best opinion which will probably keep the business going. And the problem again is at multiple levels. The problem is lawyers tell their clients that, look, the civil system is so slow and so jam-packed, there's such a clog that you're not going to get anything effective unless you start a parallel criminal proceedings, which will put probably extra pressure on the other side to act or not act, depending upon what the matter is. So again, that's a problem. I completely agree with you. That's a problem with the legal advice that people like us give, that lawyers give.
Correct. And no offense to any lawyer. And if you're taking an offense, well, we should move to the next question. Yeah. So another thing which happened with one of the Allahabad High Court judge who was, I think, transferred there. Justice Varma's case, pile of cash found. What are your views? Because I think now recently Parliament has also taken a view that a special committee has been formed and they are looking into it. क्या हुआ एकदम, मतलब, because a very big question mark on the judiciary.
So, Simarjit, my views on this may not align with the majority view that is ongoing, or that is like that most people hold on this issue.
I think most people are holding the views which the news is showing.
That's true. That's true. But at the same time, I personally believe, and this is born out of the kind of practice that I do, the kind of people that I work with, the value system that is ingrained in me by virtue of what I believe in, basically. I think that no human being should be condemned unheard. And that applies to a judge as much as it applies to you and me, common citizens. What has happened in Justice Varma's case is that basis things which are yet to be proved, basis things which prima facie are a little incredible. There has been a huge media trial.
Correct.
There have also been a series of missteps also by the Supreme Court in the case, where videos have been released to the larger public, which have kind of solidified an opinion against the judge, who was not allowed to cross-examine witnesses, lead evidence, at least in the in-house committee proceedings that happen, because you don't have the right to do all of that there. What I think is that this committee, as per the Judges Inquiry Act, which has now been constituted by the Parliament, what I would want as somebody practicing law, as somebody who believes in the validity of the law which governs this aspect of supposed misconduct by sitting judges, is that Justice Varma, through his legal counsels, should have the right to defend his case just like an ordinary person enjoys those rights. He should have the right to cross-examine witnesses. He should have the right to lead his own evidence. He should have a right to present his own version of things. And only after a thorough application of mind, a proper adjudication of his case vis-a-vis the case that has been put up in the media, or that the case that has been put up by the other in-house committee report, I think there has to be an equitable view of things. A judge cannot be condemned because he's supposed to be above suspicion. I mean, basis money that has been found in your outhouse, I think a lot of people in this country can be condemned like that. A lot of people, it can happen to any public functionary in India. But that is not where you start the debate of people of constitutional importance remaining above par. And just as an aside on this issue, we attach a lot of importance to financial propriety. In our head, we think that financial corruption is probably the most heinous forms of corruption. But very unfortunately in India today, you see a lot of people sitting on high constitutional posts, making statements, or by their actions or omissions, doing things which also border on impropriety. And that impropriety may not be financial impropriety, so to speak. That may be moral impropriety. That may be impropriety by way of conduct. But in my view, those things need to be taken as seriously, because there have been judges of other courts who have, while being sitting judges, made certain statements in public which are communal, discriminatory in nature. We see little to no proceedings against those judges. We see little to no proceedings against those other constitutional functionaries.
Yes, we don't. It's
So
just because the money, the value that we
So there's a ingrained
put notion.
bias notion in the Indian psyche that the only kind of corruption is financial corruption.
Correct.
But corruption can be of various kinds, and you have to treat all those corruptions as seriously. So that is like a parting view on this issue. Otherwise, I think the committee is well equipped to decide on merits.
We'll proceed ahead to this issues, and then there is another issue which is going on, and today only the Supreme Court passed an order on the stray dogs issue.
Right.
Yeah, I found one thing very weird, that the individual has to pay 25,000 to be heard, a deposit it in the Supreme Court registry. The same will be used for the shelter homes and everything, and the NGO has to deposit 2 lakh rupees. Like, is it the first time Supreme Court is introducing something of that sort?
See, Simarjit, I don't know if it is the first time, because it's a very difficult question to answer if the Supreme Court is doing something like this for the first time. But there's a trend that I notice in courts all across, including the Supreme Court and the High Court, where the tendency of the court is to shift the burden from the state and put it on the individual. Now, it is the state's responsibility to ensure that welfare of the stray dogs and protection of, say, children on the streets or people from marginalized communities who do not live in pakka houses or slum dwellers in different parts of India. These are the people who are the most disproportionately affected by dog attacks or dog bites. So it is the state which has to balance those rights. And I think it is okay for these dogs to be immune, for the dogs to be vaccinated and then left back then released back in their respective areas. But the cost of rehabilitation or the cost of vaccination, whatever it be, cannot be shifted from the state to the individual.
Correct.
Because at the end of the day, the system that we live in it continues to be a welfare system. It continues to be a welfare state, where it is the state's responsibility to balance welfare of human beings with welfare of these dogs who otherwise have nobody is there to tender for them, and they of course rely on like good good natured people of our communities to like to fend for them, to feed them, to take care of them. So you cannot shift that onus on dog lovers or like NGOs, because those NGOs are doing it out of their free will, out of the goodness of their heart, and because they're taking that extra effort, because honestly not a lot of us are taking that extra effort. So to saddle them with extra responsibility for the goodness of their heart is not something that a constitutional court should do.
Correct.
In fact, the monetary burden of it should be on the state. The state should take the burden. The individual should not take the burden.
There's another notion that since I think just a differing view, that Supreme Court also saw that there are a lot of petitions being filed by the dog lovers, by the NGOs, and just to actually minimize it, because every affidavit which is being filed there, every pleading application which is filed with it, it needs to be heard. And just because that, okay, if you want to be heard, deposit this much. So is it just because to reduce that burden as well?
You may have a point there, Simarjit. See, one of the intents of the order may be to dissuade people from flooding the court.
Because now in the first direction it was that now it is now it is a national issue. Otherwise it was only till the NCR, but now it is a national policy which they are planning to formulate.
Absolutely. No, but even if the intent is that, even if the intent is to dissuade people or to ensure that only genuine people come to court, that is not something that you can do. Because the right to come to court, the right to come to Supreme Court is a fundamental right.
Correct.
It's a right protected under the Constitution and not anywhere else but in Part 3. You can come to Supreme Court. Whether the Supreme Court grants you an effective hearing, whether they think your case is liable to be dismissed or whether it should be entertained is of course the judge's prerogative. It is their discretion. But you can't put a monetary condition on people approaching courts. So I think that is something that could have been avoided. That is not really the way that you dissuade people from approaching court. There are other ways to do it. I mean, in all of these other matters where there are a lot of petitioners, you see that there are hundreds of petitioners, and what the court does is it devises a way of giving some time to all the counsels so that everybody has time to put their unique point forward.
Correct.
Of course, there is not enough time in our courts for regurgitation of the same points from each petitioner. But if somebody has a new point to make, they should be able to do it.
They should be allowed.
Yeah.
Proceeding ahead, are you planning to challenge that direction?
Which direction?
This of depositing.
I am not a part of this litigation, and honestly, I mean, I don't know whether I'll challenge it or not because I don't have anybody to challenge it for.
Correct. We also need.
But I really don't think, to answer your question seriously, I really don't think this is a matter that has a dearth of lawyers. There are quite a number of spirited lawyers, professional, committed lawyers, not committed to the cause, but committed to the profession, and then lawyers committed to the cause as well. So I know personally, I have friends who are lawyers and quite committed to the cause, and they are doing whatever they can in their capacity.
And I think that it will be challenged. At least this thing may be a.
Let's see. I mean, this is an order by a 3-judge bench. So let's see what options those other lawyers exercise.
Yeah.
It won't be me, but I'm sure lawyers will be thinking about it.
Whenever whosoever will do it, we will play this part and we will check. Yeah, going ahead and very general now and getting aside from the serious discussion, थोड़ा सा एक कॉन्स्टिट्यूशनल लॉयर्स के लिए क्या 3 स्किल जरूरी हैं?
I would say you need to read up a lot. That's probably the most fundamental basic part of it. And when I say you need to read up a lot, you just don't need to read up law. You need to read up on all associated disciplines. Because most of the times in constitutional cases, what you argue is not law. You argue, say, if it is a case of, if it is a case deciding the validity of a criminal legislation, then you also discuss criminal psychology. You also discuss criminology. If it is a case, for example, let me give you let me give you the example of the 7-judge subclassification and reservation case. Now that case is a constitutional case, but what you argue in that case is the history of social discrimination in India. What you argue is how reservations have worked in India, whether reservations have actually percolated or not. Has reservation actually reached the most marginalized of the marginalized communities, the untouchables within the untouchables? Now, these are not legal arguments, so to speak. These are sociological arguments. So I think first thing, as a constitutional lawyer, or I would say as a lawyer in general, you need to read up a lot on associated disciplines. Second thing, you need to keep your eyes and ears open. You just cannot rely on a lot of theoretical reading, because as a constitutional lawyer, you also need to have a lot of court craft. I can only speak for myself because I'm a junior counsel assisting in these matters. So your senior or the person that you're assisting will be focused on the arguments, because ultimately it is they who are going to present those arguments to court. As a junior counsel, you have to be on top of the matter, and you have to see what arguments are being made by other counsels in the matter. How are the judges reacting to those those arguments? What is the other side saying? Because many times in these matters, you have to change strategy midway, depending upon the response of the bench, the arguments coming from the other side, the arguments already used by your co-counsels. So this is the second thing. You have to be very vigilant. You have to keep your eyes and ears open. And the third thing I would say, is there a third thing? I think there are only two things.
Oh, interesting.
You can probably say keep your eyes open, and third thing, keep your ears open.
I was about to say the third thing is to go back to the first and the second thing.
Probably. Maybe. I agree. I may not as of now think of something, but like maybe with experience 2 years later, I'll be able to tell you something else.
I'll sit again with you. So, Harshit, if there is one landmark case which you could ask everyone to for sure read it, which one will it be?
That's a very broad question, Simarjeet, because see, there are landmark cases in every sphere of law.
Correct.
In terms of what is relevant in this country right now, I would let me give you 2-3 domains and then tell you what is relevant right now and what should be read upon.
Correct.
So in criminal law, I would say everybody should read up on these special laws like UAPA and PMLA. You should definitely read the Vijay Madan Lal Chaudhary judgment of 2022 for PMLA. In UAPA, there are very many cases, but rather than reading celebrated cases in UAPA, you can probably follow trials of UAPA detainees who have now been behind bars for a long time without any substantial progress in their trial, having served already 4 years, 5 years in jail.
Under trial.
Yeah. So you can read up on their cases, like students or like anybody who's interested can read up on their cases and see as to how criminal prosecution actually happens in India. In constitutional law, I think because of Justice D.Y. Chandrachud's tenure as he then was, there has been a lot of development in constitutional law jurisprudence in the last 2-3 years. A lot of cases of seminal importance have been heard and judgments have been passed. So I would say you should definitely read the Article 370 verdict. I will not comment on the judgment, but you should still read on it. Read it. You should definitely read the Electoral Bonds judgment, especially because the ECI now is now in news, and the electoral process in India is right now in news. You should definitely read the 5-judge bench decision in Anup Barnwal from 2023, which called for an independent election commission without an interference from the executive. Also put in the Chief Justice in the selection panel for a brief period, which was then overturned by a law of the parliament. And lastly, other than these, I have already covered criminal, I have covered constitutional election commission. Maybe in commercial law, you should, I forget the name of the judgment, but maybe, and this might again be not a very a popular choice of judgment, but you should read the judgment, if I'm not getting the name wrong, maybe the judgment of Bhushan Steel by Justice Bela Trivedi before she retired. Now, that is one judgment that has now been recalled again, if I'm not wrong, and that has been heard afresh. But I myself found to be agreeing with the judgment. Now, that is the judgment of the IBC. I will not go into the boring details. There's an aspect of the judgment that I very vehemently agree with. on the rights of small creditors in the IBC scheme. And you may not agree with the judgment, and the judgment actually upset a lot of things which were already established and a lot of events that has already happened. But only to understand the jurisprudence of IBC and the inequality that lies within that system of repayment of money, you should read that judgment definitely on the commercial side of things.
Understood. So I got it that these are the few judgments that we really need to go through them. But now you tell me, you have worked on electoral boards, Waqf board, Article 370. As of now, what is the biggest constitutional question in our times?
If I were to answer your question in one line, I think the biggest constitutional question of our time is what exactly is the relationship of an Indian citizen with the state right now? And it sounds like a broad, abstract question, but there's a reason why I'm saying this. It's because, in my view, that relationship of the state with the citizen or the citizen with the state is something that has gone a fundamental alteration. It's still undergoing a fundamental alteration as we speak. Because what you see today, and I say this with a lot of responsibility, what you see today is a constant attack on an individual's right to be a citizen in India. And citizenship, as you know, as it is often referred to as, it is the right to have rights in a country. Because all your entitlements, most of your entitlements, in fact, flow from your citizenship. What you see in India today is that, like this revision of roles, there are valid, eligible citizens of India who are being thrown out of electoral rolls. 2 months ago in Delhi, you were seeing indiscriminate demolitions of houses. Now, those demolitions were happening, in my view, those were happening illegally, and that is yet to be proved in a court of law. But those demolitions were nonetheless happening without due regard to the policy in accordance with which they should have happened. You also see Indians who speak a certain language being thrown out of the country on the mere suspicion of not being Indians. And what I'm trying to tell you is that you see a pattern emerging from all of these different incidents. The pattern is that the ground beneath your legs as a citizen is very shaky today. Whereas the constitution, when it was first enacted and when it was first being implemented, always gave the benefit of doubt to the citizen. And the citizen always came first. And that is how you envisage any welfare state. That is how you envisage any egalitarian, democratic society where people elect their government. And the government does not elect their voters.
Correct.
And that is something which, in my view, today is under attack. So in all of these constitutional battles that you see, if I can call those battles in courts of law happening these days, you will see that the underlying thread is the relationship between the individual with the state. And that relationship in the last few years, I think, has undergone a fundamental change.
So I understood. So just last two questions. If you have to explain to a layman what exactly is Indian Constitution, what will you say?
The Indian Constitution is your entitlement, first of all, to be an Indian. Number two, to enjoy all consequent rights as an Indian. These are all your basic rights. Your right to live with liberty, your right to live with dignity, your right to not get arrested at whims and fancies, your right to send your children to school, your right to good, dignified employment, your right to have a decent family life. And in fact, that is what the Constitution is all about. The Constitution, it may have complicated provisions, but the intent of all these provisions is to safeguard those basic rights and liberties. There are certain sets of do's in the Constitution, and there are certain sets of don'ts. The don'ts prevent the state from taking away your rights arbitrarily. You cannot be arrested arbitrarily. Your freedom of speech cannot be taken away arbitrarily. These are the don'ts. And then there are a set of do's where the state has to provide you a dignified life. The state has to provide health to you. The state has to provide clean water, clean air to you. So all your entitlements as a citizen or even as a non-citizen, because Article 21 rights are for everyone.
Everyone.
So as an individual who exists in this country, all your entitlements flow from a document, and that is why you every time you have to stress on a right in independent India, you have to go back to that document and you have to trace your right from that document. All laws, all notifications, all bylaws trace their genesis or their basis in that one document.
Understood. Understood. Last question for the day. From here, where do you see yourself in next 3 years?
That's the most difficult question that you've asked me today. And you saved your best for the last. But if I were to answer you with some seriousness, I see myself practicing law. I see myself doing rights-based litigation. I see myself doing public law work because I really enjoy doing public law work. I won't be wrong in saying that it gives my work a sense of purpose and meaning, especially in a country like India where most people do not have the means or sufficient information or knowledge to press for their own rights. We have a liberal, welfare-oriented constitution, but the truth is that most people don't actually know or don't actually feel that they are entitled to those entitlements, that the state actually owes them something. And what I feel most satisfying or the most content doing is, to put it in a very cliched manner, being the voice for somebody who cannot speak for themselves. So while I of course intend to do like all kinds of law practice, because honestly I do enjoy law practice. I enjoy commercial side of things. But at the same time, I want to focus on rights-based litigation. And honestly, wherever I have an opportunity to represent someone who is in clear need or who actually is lacking the means, I would always want to take it up. I am not saying that I am the only good Samaritan who is willing to take it up. Honestly, there are a good number of lawyers doing it day in and day out in all our courts, not just the Supreme Court, in our trial courts. I have very close friends doing it without the need for any kind of validation from anyone. And I just hope to be a part of one of those people.
That's amazing. Thank you so much, Harshit, for your time. And I know that we both, as of now, are under the weather and still having this kind of serious conversation and learning. I actually learned a lot of things today.
Same.
Thank you so much,
Thank
Harshit,
you.
for
Thank you,
your time.
Sanjay. Thank you for this. Thank you.
वाओ, लाइक मतलब बहुत कम होता है कि हमारी कॉन्वर्सेशंस में हम लोग एक्चुअली इतना कुछ सीख पाते हैं, एंड दैट टू फ्रॉम समवन हु इज वर्किंग क्लोजली with the constitutional benches of the Supreme Court, working on the landmark judgment which we are seeing since last 3 years. And I am really fortunate enough to actually learn all of these things from Harshit sir, and I really hope you also learn what exactly is going on with the Bihar SIR case, then the Justice Varma controversy which all happened around. In the stray dogs ka hum log we discussed a very small part, but I hope you really liked it and learned a bit. And if you did, please do share, like, comment. Thank you so much, everyone.